All right, folks, buckle in because this case is a wild ride right from the jump. Today, we've got a defendant who's not just dealing with one serious charge. He's allegedly connected to a fatal DUI in another state and caught driving nearly 100 miles per hour here at home. The judge is already irritated, the prosecution is fired up, and the defense is scrambling to explain how all of this got so out of control. Pay attention, because the tension in this courtroom goes from 0 to 100 faster than the defendant's radar reading. Major contradictions, emotional appeals, and one judge who is absolutely not having it. This is a courtroom showdown you don't want to
Makes me very
miss.
happy. Looks like you're wanted out of another jurisdiction for a DWI causing death.
Yes, sir.
And now we have you here because you picked up a reckless driving. You want me to let you out?
To go to Mississippi. Yes, sir.
It's cute. I don't even know what happened. Let's figure out what happened in the reckless driving.
Judging the reckless driving, on August 25th, 2024, officers were patrolling the southbound of the 7600 blocks of East San Luis Tollway South. Officers observed a defendant in a black lifted truck traveling at a high rate of speed. The officers captured it speeding for radar at 97 miles per hour in the 65 mile per hour zone at the 9200 block of San Luis Tollway. As officers attempted to catch up to the vehicle, the officer observed the defendant cut across different lanes of the highway while failing to signal and cause other vehicles to brake. Officer observed the vehicle following other vehicles closely as it cut up.
Don't say anything specific, Judge. I would like to state that this case is out of court 14.
My concern is for public safety. He's already killed someone on the road with the DWI, allegedly, and now he's driving at near about
And
100
here's where
miles
the
an hour.
case starts to take shape. Notice how the officer's report immediately escalates things. 97 miles per hour in a 65, weaving through lanes, causing other drivers to hit the brakes. This isn't a minor lapse in judgment. This is exactly the kind of conduct that judges view as a flashing red warning sign, especially when the defendant already has a pending out-of-state DWI causing death. And viewers, what do you think? Should his past alleged actions impact how the judge handles this reckless driving arrest? Or should each case stand alone? Let me know in the
Driving
comments.
at near about 100 miles an hour, weaving in and out of traffic, causing others to brake around. And you want me to set you a bond? Really? I would like hair.
I can get.
It's not going to happen though, man. Not as my wildest dreams, as much hair as I want. I'm never going to get it back. Perhaps I can get plugs, I guess, right?
Judge, if I may, Judge. Judge, so this is a fugitive case. The basis of the fugitive case is for him to answer in the demanding jurisdiction. He had no notice that this case was open. It sounds like the comparison here to Harris County would be a 2B warrant. Nobody notified him of a court date, a court setting. The actual charge is violation of a court order. So I'm assuming they want him to present
I don't know
himself.
that. How do you know that?
There has been no presentation made besides him having a fugitive case. If
How
that's
long has this case been open, Amy?
Judge, I do not have that information at this time.
And that's the problem with these cases. We don't have the information. So just on the information we have, he's got a fugitive case, violation of a court order. I would ask for him to be allowed to answer for that. Is regarding public safety, he's answering for that in court 15. He's answering for that in Mississippi. This case is just to assure that he makes it to Mississippi to present himself, to avail himself to their requirements. He hasn't had the opportunity to do so. This is the first notice he's had from what he's telling me that he's had to present himself, and he's got a plan in place to do so. He hasn't messed up in your court before. I'm asking for the opportunity for him to go turn himself in. If he messes up, okay, fine. At that point, we have no answer for why he messed up. But right now he's saying he was just made aware of this when he got arrested for this. He wants to answer for it. I'm asking for the opportunity for him to do so.
Your Honor, if I may, I have a newborn son, and I'm trying to resolve all of this. because I can't do this again. I don't need to do this.
Just did.
Yes, sir. I'm
You just,
talking about being away from him. I have
love and appreciate your tenacity. But I think that you are a complete danger to our streets. We lead here in Harris County, the nation, per capita, in fatalities related to drunk driving cases. We, if you watch the news, every single day have someone dying on our roads because of someone who is making a boneheaded decision to drive like a freaking maniac.
Now, this moment is huge. The defendant brings up his newborn son, and emotionally, this is a powerful plea. Defendants often emphasize family responsibilities to show stability and urgency, hoping to sway the court toward leniency. But remember, judges must weigh emotional appeals against the risk the defendant poses to the public. And this judge, she's already framing him as a significant danger, especially given Harris County's staggering history of DUI fatalities. This is a classic courtroom collision, human emotion versus legal responsibility. What would you do here? Would you consider his newborn, or does his driving history override all sympathy?
Maniac. And you, not only do you have this case, but you are charged with killing another in another state while being under
he
the
was a
influence.
very, very good friend of mine, Your Honor. And
specifics. They
Uh,
will use this.
So does that make it better?
no, sir, it makes it worse.
Right.
Uh,
Judge, if I may, he is presumed innocent, Judge. He's answering for these charges. He's presumed innocent. The basis of your,
Not finding him guilty, but Ricardo, I think that he's an extreme danger to public society. He's a danger to our roads. And what we will do is I will hold you at no bond in our jail until you resolve these cases. And at that point, we will notify, or I mean, you've already notified Mississippi that we haven't, correct?
Yes, Judge.
Okay. Hey, Rick.
Judge, where he's got no other criminal history. When was this DWI?
last year,
Last year,
May.
he's had no criminal history since this one DWI and this reckless driving. He hasn't answered for him yet. He's willing to answer for him. He's got no other criminal history besides this. We don't know the specifics of either case. I can't argue for him in either case because I don't know the specifics. He just needs to answer for him.
Ricardo, he's charged with killing another on the road, and now he's driving at about 100 miles an hour. I'm not giving him a bond. You will have to wait to answer until Mississippi comes and gets you. They will take you back if they come, because I don't even know if they're going to come. If they don't come and get you at that point, you know, within the prescribed time, Harris County will release you. But me, I don't feel comfortable giving you a bond because I don't want that kind of blood on my hands. If I give you a bond and you go out there and do something, that's on me. And I have enough trouble sleeping at night as it is. I don't want that kind of blood on my hands.
Judge, can we do any other kind of conditions that you would find reasonable to?
I promise you, Your Honor, my
I know
son
that
is
you're
a
going
lot
to
more
promise me
important
it's
than
gumdrops and tulips and little bunnies jumping in the woods, but I don't believe you.
His wife can drive him to, we could sign a no driving affidavit if that's your concern. As long as it gets him out of jail, he will make efforts to get over there. He will sign a no driving affidavit if that's what it takes, correct?
Absolutely. Yes, sir.
And he's got a plan in place. His wife will take him over there. He works at the refineries. I don't think money's going to be an issue for him. He's a welder, supervisor, something up there, inspector. And so he's got a plan in place. Holding him in jail for 14 days to wait for Mississippi is already punishing him for something that he hasn't been convicted of. He's got, we could find other alternatives to allow him to go over there. He could show you a bus ticket. He could.
I'm not giving him a bond card. I'm sorry. You're going to have to wait until Mississippi comes and gets you. And at that point, you can answer the charges, but I'm not letting you out. Sorry. Just
So
too
to
much
wrap this
blood.
case up, the judge ultimately denies bond, citing extreme public safety concerns. With a prior DWI causing death in Mississippi and this new reckless driving charge in Texas, the judge makes it clear she won't risk releasing someone she views as a potential repeat threat on the road. The defense raises strong points about due process, lack of notice, and alternative release conditions, but none of it outweighs the judge's emphasis on community safety and the state's tragic record of DUI-related fatalities. It's a powerful reminder of how judges must balance compassion with accountability. And in this courtroom, safety won decisively. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.